The other thing is, so in the gas tank case, they said if the search is particularly offensive, then maybe we'll require reasonable suspicion. And the court attempted to describe why it wasn't particularly offensive. And the way that they reached this conclusion is very convoluted and it's difficult to understand. So I apologize in advance, but I'm going to try to explain it to you. Basically, a warrant is not required to search a car. The reason is that a car can drive to a different jurisdiction, and it takes time to get a warrant. You have to call the judge and go through this whole process. And while you're doing that, a car could leave wherever it is and go somewhere else where you don't have jurisdiction to search it anymore. So you don't have to get a warrant. The police don't have to get a warrant to search a car. But they do have to establish probable cause, which is the same standard of suspicion that they would need to establish if they were going to get a warrant. It's just that the warrant process, the bureaucratic process, isn't there. So there was this guy who was selling pot out of his mobile home, and the cops searched it. They established probable cause, but they didn't have a warrant. And he went into court and he said, they should have gotten a warrant. It's my house that they searched, irrespective of the fact that it's a vehicle. And the court held that, no, it's a vehicle, and for the same reason that they don't need a warrant to search a car, they don't need a warrant to search a mobile home. The fact that it's also your home is irrelevant. What's important is that it can move from jurisdiction to jurisdiction. So in this laptop case, the Ninth Circuit relied on that rationale to argue that you know, laptops are readily mobile, and you know, because of that, no reasonable suspicion is required, and it's hard to even sort of explain how they related these two things together. In my view, there's a difference between the concept of the standard of suspicion and the bureaucratic process required to prove that you reach that standard of suspicion. So the fact that there's no warrant requirement for a vehicle, well, we can understand that, but at the same time, you still have the same standard of suspicion. They still have to establish probable cause. At the border, a reasonable suspicion is a standard of suspicion. Establishing it doesn't introduce any delay. And so this whole concept of laptops being mobile, you know, is completely irrelevant because there's no bureaucratic process they have to go to. If they look at you and they say, I have reason to suspect you're a crook, you look like a crook, and here I've got some reasons that I think you're crooked, that's enough. So in my view, this is extremely sloppy, and I'm sorry if that was unclear. The reason it's unclear is because it's a really sloppy decision and it doesn't make a whole lot of sense. But you know, currently that's the law. And so a lot of people are reacting to this decision because it has huge implications, because it was a sloppy decision, and because there's a chance that it could be upheld. The other thing that happened shortly after this decision was handed down was the anti-counterfeiting trade agreement, which was leaked on May 22nd. It's really unclear what's happening here. It's a bunch of countries getting together, but what they're talking about, I'll read you this quote from Canada.com. They said, the deal would create an international regulator that could turn border guards and other public security personnel into copyright police. Security officials would be charged with checking laptops, iPods, and even cellular phones for content that infringes on copyright laws, such as ripped CDs or movies. The guards would also be responsible for determining what is infringing content and what is not. So that's the other shoe, right? I mean, most of y'all probably don't have kiddie porn on your laptop, but you might have a few MP3s. Now, my view is that if they take your iPod, they can't tell whether or not the contents of your iPod are legally obtained or not. But if you have like Bear Share on your laptop or something like that, and you've got like a incoming and outgoing directory, and you got a bunch of stuff in there, you know, that's probably prosecutable. And you know, we're looking at a real situation where customs agents could begin searching people's laptops specifically looking for that, just as they used to look for Beanie Babies. It's not just serious stuff they look for. Sometimes they do look for intellectual property stuff. So what has happened? This case will be appealed to the Supreme Court. The people who like this status quo have argued that it's possible that that appeal will be denied. We'll see what happens. Hopefully, one of the reasons that so many people who are concerned about this are making a lot of noise right now is so that the Supreme Court knows that people are watching, and hopefully that will make it more likely for them to take the case. The Washington Post has reported that law firms are asking employees who travel to keep 2 laptops. One laptop for use at home and another laptop for travel. In some jobs, that's actually fairly reasonable, even regardless of U.S. policy. If you're going to go to China, it's possible that the Chinese government could search your laptop. So you might not want to take all your trade secrets with you. There's some real concern about that, but that concern is growing because of our searches. And the problem is when we go to China and we say, really, we're worried about the fact that you're searching laptops, we'd rather you didn't do it. They're going to have a hard time making that argument because we're searching laptops too. We're searching Chinese people's laptops. So, quid pro quo. It's a real problem. Jennifer Granick, who some of you may know, she's an attorney at the EFF. She posted some advice for travelers. I'll talk about that a little bit more later. Also, the EFF wrote an open letter to Congress, and they said, have hearings on this. And they also filed an FOIA lawsuit in order to learn more about border search practices. So it turns out that Congress listened to the EFF, and they actually held a hearing. The Senate Judiciary Committee held a hearing on June 20th, 2008, so that's a big win. And you can go read some of the testimony, and you've got testimony from all sides of the spectrum on this, except for from the Customs Service itself, which is kind of frustrating. There was an editorial on July 10th from the New York Times who said, this is bullshit, don't do this. There was an editorial. So Michael Chertoff, who is, I think, the DHS director, wrote an editorial in the USA Today on July 16th, kind of responding to the New York Times editorial. In that editorial, he says, travelers only go to secondary when there's some level of suspicion. Legislation locking in a particular standard for searches would have dangerous chilling effect, as officers often have to make split-second assessments and are second-guessed. So what he's saying is that they do employ reasonable suspicion, but they don't want it to be the law because then, their judgment might be second-guessed. So, and I'm going to get back to that Michael Chertoff quote in a minute because that became a matter of some controversy. And in any event, I actually spoke on this subject at Hackers on Planet Earth in New York City on July 20th. And there I was the first person to publicly announce this thing called Hands Off My Laptop, which is run by the Center for American Progress, which is a Democratic think tank in Washington, D.C. There's actually someone here at the con from CAP, but I don't think he's in the room right now. In any event, the number of people who responded to that thing because of me was probably pretty small, but CAP has a very large network, and so there were thousands of people who signed up on this website. It's essentially a petition. It goes to DHS, and it asks DHS to do a privacy impact study of their policy to see how many people's laptops are searched, how many people's laptops are seized, and how many prosecutions does this net. So anyway, I think that was a successful campaign, and that campaign's still ongoing. But 2 weeks later, DHS published their laptop search policies. So that's kind of a success. They're at least becoming more open about what it is that they're doing. So let's talk about what these policies consist of. First of all, they say, notwithstanding this law enforcement mission, and this is one of the first things they say in the course of every border search, we'll protect the rights of individuals against unreasonable search and seizure. Thank you very much. As far as I know, there is no imaginable search or seizure which is not authorized by this policy in this context, so that's a little silly. But in any event, in the course of a border search, absent in any individualized suspicion, they can review and analyze the information transported by any individual. Officers may detain documents and electronic devices or copies thereof for a reasonable period of time. So, essentially what we knew has now been admitted to by the Customs Service that they will look at anything that you bring in and they can seize it without individualized suspicion. Except as noted, now this is important, except as noted in this section, if after reviewing information there exists no probable cause to seize it, they will not retain it. I'm not sure that, they do destroy the data if they decide that they have no reason to prosecute you. If the alternative to destroying the data is keeping it, and keeping it would require an infrastructure for keeping it, and so that would cost money. So it may simply be the case that they've decided that they don't want to spend money keeping the data, and not the case that they're destroying it because they want to be nice to your privacy. In any event, there are 3 classes of information they spelled out as being special. One is business information. They'll treat business information as confidential, and they'll take all reasonable measures to protect that information from unauthorized disclosure. I would hope that they would also take all measures to protect non-business information from unauthorized disclosure, but be that as it may, there are actually things like the Trade Secrets Act that they could be held liable on if for some reason they obtained business information in the course of one of these searches and disclosed it. So that's why that's there. They don't open letters. in the mail, which is not really, it's a little outside the context of this question, but they spelled out that if a letter is in the mail, they won't open a letter. They may open a package in the mail, but not a letter. And by the way, DHL, UPS, and Federal Express are not the mail. And furthermore, having a letter that's sealed in your luggage is not the mail. It actually has to be in the mail. The other thing they mentioned is attorney-client privilege material, and it's kind of clear, the wording is a little weaselly, but it's kind of clear that basically they're concerned about a situation where they're prosecuting somebody, and the opposing attorney ends up getting randomly selected for search, and he's got the information about the case on the laptop, because if their agent obtains that information, then that could undermine their lawsuit. So, you know, what they say is if it smells like that, then they need to talk to the chief counsel or the U.S. Attorney's Office. So essentially, these things are to protect the customer service. They're not to protect you. The second sealed class letter mail issue is related to a federal law. So again, any search is essentially authorized. The one good thing is that they're not retaining the data after they're done looking at it. So a week after this information was published, Chertoff did an interview with Wired magazine. Wired said, wouldn't it allay the suspicions of the business community if you had a policy that says we only search through laptops if we have a good reason to do so? And Chertoff says, that's exactly why I put it on the internet. It's on the web to say we only do it when we put you in secondary. We only put you in secondary when there is a suspicion, when there is a reason to suspect someone. He uses these words, reason to suspect. Well, you just saw the words from the policy. I'm going the wrong way. Yeah, you just saw the words from the policy, which I pasted in this morning, or actually yesterday. It says, absent individualized suspicion, officers can review and analyze the information. It doesn't say when we have a reason to. It says whenever we want. And so Senator Russ Feingold, who's from Wisconsin, called him out on that, and he says, Secretary Chertoff's blatant mischaracterization of the DHS policy contradicts his claim to be engaging in greater openness on this important issue. His statements make it clearer than ever that we must work to protect as we work to protect our national security, Congress must also act to protect law-abiding Americans against highly intrusive searches. Feingold wants to make it illegal for them to search your laptop without reasonable suspicion. And he did catch Chertoff at least being misinformed, if not being dishonest. So Wired went back to DHS, and they got this guy named Russ Knock, and he says, oh, this is just sour grapes and paranoia from someone who can't accept that even the Ninth Circuit ruled that what we're doing is constitutional. So that Ninth Circuit ruling he's referring to is the one that I tried very hard to explain to you before that was completely nonsensical. So I you know, when they start referencing that Ninth Circuit decision, I don't take them very seriously because that decision is very sloppy. The WAPO on August 13th, this is the last thing that I know that has happened around this issue. They published an editorial on August 13th, and they kind of subtly acknowledged this exchange between Chertoff and Feingold. And then they said, you know, even though DHS says that they only do it when they have reason to suspect something, that should be written into law. So you now have both the New York Times and the Washington Post saying that this should be written into law. You know, I'd say that there's a consensus forming there, although, you know, perhaps both of those could be accused of being liberal media. I don't know if someone's going to take the opposing view in the room. In any event, that's where things stand today with respect to this issue. I hope that the Supreme Court does pick this up and analyze it. You know, and there's you know, possibly going to be some congressional action, but you know, it's a developing situation, and it's important. I'm glad that you're all here because it's important that people are aware of the situation. It's important that people if they're concerned about it, are communicating with their legislators about it right now, because this is when decisions are being made. So what can you do to protect yourself from a random search? Everyone always asks this question. A bunch of people have written about this on the internet. A lot of people say, well, you should encrypt all your data. So the question is whether the customs agents can force you to turn over your password. Granick says that one federal court ruled that you have a Fifth Amendment right to refuse to reveal your password. You know, it's you have a right to not incriminate yourself. And so if they ask you to give your password, you could say, I plead the Fifth. It's an interesting argument. Unfortunately, it's controversial. Orrin Kerr, who's a law professor at George Washington University, says the password itself is not incriminating, only the information it protects, and therefore you have no Fifth Amendment right to refuse to reveal the password. They can throw you in jail if you refuse to reveal the password, because the password cannot be incriminating in and of itself. I think that's a bunch of bullshit, but in any event, that question is going to continue to be litigated in the courts over the next few years, and it is undecided.